And so the Trump administration, in the lead up to the Memorial Day weekend, has decided to issue a new policy memo on adjustment of status. And if you read the news reports and you read the press release, it's the end of the world. There is no more adjustment of status. If you read the memo, however, and let me take a step back and say this. I actually have not read the press release. I have, however, spent my Memorial Day weekend studying this memo, but I have not read the press release because that's just written by some administrative hack. And frankly, the point of the press release is to scare people. And the point of the press release is to kind of live in the heads of immigration lawyers without paying rent, as President Trump has done so extraordinarily well. So I have made a conscious decision to ignore the press release and frankly, to ignore the press reports that have come around it. Instead, I've studied the memo and it's pretty bad, but not the end of the world, and not the end of the world for a number of reasons. Some of the more level-headed immigration lawyers who I like to listen to and exchange ideas with have pointed out that, well, last August, the administration put out what was at the time considered a horrifying memo about naturalization and good moral character in that context. And while we all lost our minds back then, in practice, it turns out not really to have changed anything. And that's a good point, but unfortunately not a dispositive one. And I say that because the language in that memo was far more moderate. The administration or the author of that memo really seemed to be trying to withstand federal court challenge. This memo is making no effort to do that whatsoever. And I say that for two reasons. First of all, and what I find to be the most horrifying part of the memo, quite frankly, is the explicit reference to the fact that the decisions on adjustment of status made by immigration officers are not appealable to the federal courts. I find it horrifying because I absolutely read it as a direct invitation to these people to abuse their discretion, to make denials that they probably shouldn't be making because they don't have to fear that there's a federal judge looking over their shoulder. Now, while I find that horrifying, I also find it somewhat encouraging because this memo is a direct challenge to the federal courts. And there's a lot in this memo for the federal courts to take umbrage with. And as I'm expecting a great deal of litigation to come out from under this memo, I'm expecting that line to feature prominently because it is a direct slap in their face. It is a direct attack on our system of law, quite frankly. And I expect them to read the rest of the memo in that context. And the rest of the memo actually does not really pass legal muster. It talks a lot about congressional intent and how Congress intended that, the adjustment of status process not be automatic, and that Congress intended that the Immigration Service would take into account how it came about that people were petitioning for adjustment of status as opposed to going through normal consular processing, which, let's face it, is the kind of default position for people to get green cards. However, all of the Board of Immigration Appeals cases that this memo relies upon, and all of the really good language that this memo relies upon in saying that that was the intent of Congress, and in saying that immigration relief is, or adjustment of status is extraordinary relief or an act of grace or anything more than discretionary, is all pre-1997. And I mention 1997 because prior to April 1, 1997, prior to the 1996 immigration reforms, prior to IRWA, which, as I say, passed in 1996, took effect April 1, 1997, people who entered without inspection, what we immigration lawyers call EWIs, people who entered the country without a visa, without being paroled in, were allowed to adjust status. And so the idea that Congress said, okay, you can adjust status, but, we do want the Immigration and Naturalization Service, as was called back then, to take a closer look at you and make sure that you are a person of good moral character, kind of makes sense. However, even pre-1997, these folks were getting adjustment of status, and getting it quite commonly. Now, when Congress changed the law in IRWA, and keep in mind, that was an extremely immigrant unfriendly decision. I mean, that was, or immigrant unfriendly law. That's the same law, for example, that made aggravated felonies essentially a death sentence in the deportation context. I mean, this was a brutal law that every immigration lawyer hates with a passion. That law said that while no one who entered this country without inspection could adjust status, and in fact, no one who was out of status, so for example, a visa overstay, could adjust status except for people who were married to a U.S. citizen, were an unmarried child under 21 of a U.S. citizen, or were parents of a U.S. citizen over 21, could adjust status. There's also an exception for religious workers. But Congress clearly expressed its intent that the vast majority of people who were out of status, and everyone, absolutely everyone, who entered without inspection, could not adjust status, while allowing visa overstays and allowing parolees, and by the way, allowing everyone who was still within lawful presence to adjust status. And the case law that is cited in this memo does not address that even remotely. As I say, they recite a lot of cases from before 1996, from before the reforms, indicating that Congress took a dim view of people who did not explicitly follow our immigration laws. Although again, there's a different set of immigration laws. But it cites no cases after 1997 on the subject of adjustment of status at all, other than cases that say that adjustment of status is discretionary and thus not subject to federal court review. Now, some of those cases in saying that is discretionary cite back to other cases that in saying it is discretionary say that it is a matter of grace. But they themselves are not calling it a matter of grace, and they themselves are not calling it directly a matter of extraordinary relief. They themselves are calling it a matter of discretion and therefore not subject to federal court jurisdiction. And this distinction between discretion and grace is important because there is such a thing as abuse of discretion. And this whole policy memo, I think, can be characterized as an abuse of discretion. And the reason I think that is specifically because of this reference to the fact that this policy memo is telling frontline adjudicators, don't worry about it. Your discretion is not subject to review, and therefore you can do whatever you want. And that's not a legal standard ever. And to say that or strongly imply that is, I think, an abuse of discretion that I do not think will pass legal muster. So that's my number one take on this. There will be litigation coming, and frankly, while it's good to come in and kind of get your ducks in a row, I probably will be holding back on filings for a little bit just to see how some of these cases play out, because there are a lot of legal problems with this memo. The legal grounding of this memo is very weak. Now, I will be the first to admit that the first time I read this memo, I missed a lot of what I just said. I caught the thing about not being appealable, but I missed the fact that there was nothing really post 1996, 97 that supported what this memo was saying. I did notice my first time through that there were a lot of old decisions, but it was on my second reading that I kind of went through and started to pull apart what citations were substantive, and those were all old, and what citations kind of read as fluff, where they just kind of use these magic words, grace or extraordinary relief, but don't use them in any kind of a context. And then I kind of went back and checked the context in which these words were used. And again, the big one, Patel v. Garland, where the Supreme Court said that adjustment of status is not subject to judicial review because it's a matter of discretion, cites a case or quotes a case that quotes another case in which the standard of grace is invoked in discussing that this is discretionary relief. Because again, discretionary relief is jurisdiction stripping. But Patel v. Garland, number one, had nothing to do with how you adjudicate an adjustment of status case. And number two, never itself said that adjustment of status is a matter of grace. It just cited to a case that's, it had within a quote, the words grace as how another court got to the idea of discretion. And all that Patel v. Garland was saying was discretion. So although the memo says that Patel v. Garland said grace, the court in Patel v. Garland did not say that. I appreciate I'm getting kind of legalistic here, but then again, I'm a lawyer talking about a policy memo and why I don't think it's going to stand up. And so, yeah, I'm getting a little legalistic here. But let me say something else about the memo. It does not say that being a visa overstay is the end of the world. It doesn't say that adjustment of status is dead. It instead does a good moral character analysis, and it talks about how certain things are not indicative of good moral character. And in fact, it indicates, for example, entering on a tourist visa with the intent of staying, although that intent is something that is itself subject to challenge, because what matters is not what the person wound up doing, but what was their intent when they crossed the border. So in other words, the person came here expecting to leave in 3 months or 6 months or whatever their I-94 says, and later changed their mind. That's not coming here with the intent, that's not getting a tourist visa with the intent of staying in the United States. So even at what is this memo's, most kind of abhorrent weighting, because it is saying that that's very serious indication of the lack of good moral character. Already there's a factual dispute, case by case. But none of these things say that it's definitive proof of a lack of good moral character. It's just something you put on the scale. And this is something that, is always an issue anytime you're dealing with kind of amorphous phrases like good moral character or discretionary relief even, that kind of by definition, these are balancing acts. And while it's been nice that these things have been balanced, more or less the same ways for a lot of years, and so that as an experienced practitioner, I kind of know what USCIS will and will not accept. And thus it's troublesome to me to see them changing the rules or trying to rebalance things or whatever. At the end of the day, if they are playing by the law, they can't just say, oops, adjustment of status, discretionary relief, it's a matter of grace, it's extraordinary, so we're just going to deny it across the board. Well, that's not what Congress said. I mean, it's just not what Congress said. It's not the law, and they can't do that. And I'm hopeful that the frontline adjudication officers will not do that, notwithstanding this policy memo. Again, they did not take the invitation when the naturalization policy memo came down to do these sorts of things. And instead, I think all that they have done is that they've made, well, frankly, my job harder and everybody else's job who files these adjustment of status petitions, because now we have to start putting some emphasis on showing what great people our clients are. And fortunately, most of my clients are great people. So, we'll just put more emphasis into doing that and showing, why their U.S. citizen spouses married them in the first place, kind of thing. Because after all, most people in this country are pretty picky about who they marry, right? We marry good people. I can't believe that USCIS is so disdainful of Americans that they would think that they were running around marrying people of poor moral character, right? So we'll put some emphasis on that. It's a little bit more work. It's a little bit more of a pain in the neck. We got used to that in Trump 1.0 and had a great deal of success during the Trump 1.0 years. So far, so good in Trump 2.0, at least on the immigration adjustment of status, consular processing side of things. The deportation side has been rougher, although so far reasonably so good there, at least in terms of all my people are still here. So we'll see where all this leads, but don't give up hope. We're still here. We're still going to be doing these. As I say, I probably will be recommending in terms of actual filing that we hold back a little bit just to see where the dust settles on all of this. I do have some others pending, so I guess I'll know soon enough, and we'll go from there. But the policy memo does not say adjustment of status is dead. It does not remotely say adjustment of status is dead. It just gives us more hoops to jump through, more hurdles to jump over to get to the promised line on adjustment of status. And in the meantime, I'm not sure this policy memo will stand up at all. So if you have any questions, if you need any help, you know where to find me. I'm at 16 Pine Street in Lowell, 978-459-8359. Please feel free to call or text. And I look forward to seeing you soon. Thanks.